Thank you, Khushi.
No worries, ma'am.
Pratik, are we good to go?
I haven't received it yet.
Right. So, Dimitra, I'll be asking questions along with you according to the document. And perfect. Ancha, I think we can start. It'll go live. We can start.
All right.
Or should we wait 1 more minute since it is still 1 minute to go?
Sure, there is no problem.
yeah.
Wait, the clock tick.
Yeah. Thank you. So I was just saying, Mr. Batra, that pandemic has helped young lawyers in one more way that seniors, they don't realize since they're not in that position that it has given young lawyers a little more face time with judges and with courts, because now they have their face on the cam as in the meeting, and they have their name written. So initially, when they used to argue in the court, very few people knew who is arguing, even if you made a good argument.
Right.
Young lawyers, now people have started recognizing their faces in courts with their
a lot
name.
of advantages. True, very many advantages of online now.
Thank you. Pratik, can we start?
I think we should start.
Yeah.
Yes. So
Yes, we
even
can.
if the recording, we have the recording so that we can upload later. So thank you everyone for joining us today. Good evening from India. Good morning, good afternoon if you're joining us from different parts of the world. I, on behalf of AcIn's International, welcome you all to the Fireside Chat on MedAb with Sudhanshu Batra, Senior Advocate and Mediator from India. And it gives me immense pleasure to welcome you all here. I am Akanksha Marwa, as it is reflected on my screen. I am the co-founder and CEO of AcIn's International. I have been trained by the High Court of Delhi, Samadhan, and I'm also trained in restorative justice by DCP's team USA. And I organize trainings with them. We also have Upasna Singh, the founder and CEO of AcIn's International. Upasna, do you want to say something to our participants here?
Yeah. Thank you, Akanksha, for giving me that opportunity. So, good evening, good morning to all of you, depending upon your current location from where you're joining us. I can see most of our participants are from India. So, thank you all for joining us on a Sunday evening. And I extend the same gratitude to Mr. Sudhanshu Batra also here. Thank you, sir, for joining us on a Sunday evening. So, I am Upasna Singh. I am founder and CEO of AcIn's International. AcIn's International is a conflict resolution organization, and we specialize in mediation and restorative justice. I am myself trained, I'm an advocate practicing in India, Delhi, and I'm also a mediator trained by Samadhan High Court of Delhi and London School of Mediation. So that makes me certified to practice in London. And also I'm a trained restorative justice facilitator from DCP's team, United States of America. Other than that, I am an academician because I really like to teach. So I teach on visiting, I'm a visiting professor with multiple universities. So lovely to have you on board. And I cannot wait to have this discussion started, Mr. Batra here. Maybe I can invite Dimitra to introduce yourself, Dimitra, and introduce Mr. Sudhanshu Batra to our audience.
Yes, thank you. So my name is Dimitra Kumar Singha. Currently, I'm pursuing the University of London LLB while working with AcIn's International as an intern. Introducing Mr. Sudhanshu Batra. He's a senior advocate, mediator, and a trainer. He joined the bar in the year 1986 and has practiced in all courts of Delhi and across the country. Presently, he is an elected executive member with the Delhi High Court Bar Association. Mr. Batra is also empaneled as an arbitrator at the Delhi International Arbitration Center.
Thank you. Thank you, Dimitra. We
welcome.
welcome
My term as an elected designated member is come to an end. So this time I did not contest elections. So I must correct that. I am the former elected member.
So I must
Thank you
ask.
so much, Batra.
Yeah.
Yeah.
So I must ask you, Mr. Batra, why didn't you run? But then I think that conversation can be done towards the end. But before we start, do you want to say something, or shall we straight away start with a conversation today?
Please go ahead. I think you should start because I see a lot of questions lined up, and that itself might take some time to explain the concept of MEDAB and so on.
Yeah, thank you. Thank you, Mr. Batra. So I just want to start with the first question, which is, we have already introduced you, but we wanted to know more about your journey from, you are a senior advocate, you have an elaborate career in litigation and a very successful one. So what was the reason for you to decide to, when you decided to go into mediation and become a mediator? And can you talk a little bit about your journey as a mediator?
Pasna, it's, I have been a litigator, and a hardcore litigator means he has a very adversarial approach because he's really protecting the interests of his client or her client. And but I always thought that there are a lot of disputes. Of course, as litigators, we stick to our legal positions while we are arguing. The facts and everything belongs to the parties. But I always felt that, there is a lot of scope for parties to sit together and resolve their own disputes rather than, take the adversarial path, which is a very long drawn, very expensive, very uncertain, and, always sometimes very good cases are lost and very bad cases are won. And it gives a feeling of dissatisfaction. So, and in 2006, the Delhi High Court decided to set up a court-annexed mediation center. Actually, the mediation started when, in 2005, when the Supreme Court decided that they should set up court-annexed mediations all over the country. And in 2006, I remember Justice Karju was the Chief Justice of the Delhi High Court, and he invited the bar to look at this forum to pursue it. At first, we were a little skeptical. We thought that, lawyers might not approve of this because this really hits them straight on their earnings, because lawyers would feel, why should we not get the matter settled? We are to represent the parties. We're not supposed to settle them. Then what would be our role? But then we really realized that actually the need of the hour is to facilitate the parties for a resolution. And facilitation of a resolution is ultimately satisfies both the parties.
Tanvi, can somebody please mute Tanvi? We are sorry, Mr. Sudhanshu.
Yeah, that's
So
all right.
sorry, ma'am. It's okay.
So then we told Justice Karju that, like arbitration, arbitration is usually the arbitrators are retired judges of the court. And a lot of the control of the arbitration arena is by the retired judges. And we felt that mediation may also fall into that track because of the court-annexed mediation is to be started and the judges start doing mediation. Then after retirement, they'll probably be doing this. And we thought that allow us as lawyers to set up this mediation center with minimal control of the judges. So a unique model was set up by the president of the bar then, Mr. Chandyok, who was then the president of the bar. And we told the judge that we will start the center, but it should be controlled by us with an overseeing committee of the Delhi High Court comprising of judges and the lawyers who are running the center. So Justice Karju was, very magnanimous, and he said that we have no problem as long as you handle the court annex center effectively. So you'll be surprised that in the entire country, Delhi High Court is the only model which is run wholly by the lawyers, but the judges control it. So there are no mediators who are actually judges. There are, the subordinate courts and other courts, the judges also act as mediators, doing their assignments. But here we have only lawyers. And we said that the lawyers will be trained by us. So first, we wanted to get ourselves trained. We did a lot of reading. So we invited people from overseas. They held workshops. We got trained. And then we started training lawyers year after year. And initially, the lawyers were up in arms. They were just not agreeable to start this entire forum. But now you won't believe it that we have 500 applications still pending of lawyers who want to become mediators. And they realize that, once you get the parties to resolve their disputes, the parties go so satisfied with the lawyers themselves that they get more cases for them.
True.
And in fact, the earnings have increased of some of the lawyers who have acted as mediators, because they've realized that they're really looking after the interest of the clients. So then we started the center in 2006, but that doesn't mean that I've completely shifted from litigation to mediation. We do practice in court as well as litigators, but yes, we have to wear a different hat while we're in the court. And when in the mediation room, it's a different ball game altogether. So we change our hats, as I call it, and we get into the mood of a mediator, and then we start dealing with the parties or start the process. So it's a very interesting, and I think it's been very, very satisfying. Since 2006, now it's been 16 years, more than 16 years since we've done. And we also, some of us, very few of us, some senior counsels, decided to do this pro bono. So we don't take any money from either the parties in court-annexed mediations, and the matters are referred to the center. The center, the organizing secretary, marks the matters to the lawyers, considering the nature of the dispute and the kind of domain knowledge that the lawyer has. And of course, the lawyer is trained by us, and we conduct these training workshops.
All right. And Gauri, could you mute yourself? Thank you. So thank you for sharing that, Mr. Batra. And I agree with you that giving the responsibility to the lawyers was actually a very fresh touch to the entire process of introducing mediation as an, what should I say, alternative mechanism of dispute resolution. And I think we are seeing the results there, that lawyers they are actively getting involved in the process. They're becoming interested, although there's still a lot of resistance, but still there are many lawyers who are trying to, they are understanding the importance of this process. So, and even non-lawyers now, they are interested to get into this entire, they want to get trained as mediators. So do you want to say something, Mr. Batra, there? Yeah.
Yes, this was our impression, that some of the lawyers, while representing the clients, while representing the parties in the mediation forum, may resist a settlement. But my experience shows that at least 99% of the lawyers actually help the parties. It's only 1% of them that create a hurdle and deadlock and don't want the matter to go forward and settle. But that's really a minuscule compared to the large number of lawyers who are actually encouraging the parties, because they see a lot of sense in the parties getting satisfaction through the process of mediation.
Which is such a good feeling, don't you think? It is such a, seeing this sort of a synergy and a collaborative process, it is a good feeling that yes, although conflict is unavoidable, but yes, it can be resolved.
Besides being a good feeling, in our society, lawyers are considered as very difficult people in the society. They're not considered, people look at it as they want to sort of be a little wary about talking to lawyers. So because they feel that they are sort of shrewd and they have something, the underlying meaning behind their conversation. But actually, we need to dispel that. And we need to actually go out, and this forum gives us an opportunity to show that the black coat doesn't mean we are black. It actually means that we want justice for the people.
Yeah. So I don't know whether you know about this or not, Mr. Batra, but the small pocket that we have on our gowns, at the back of our gowns, that is actually added to the garment. Because initially, when litigation was introduced as a profession, advocates did not used to take the money in their hands, and they used to just turn the back, and the clients or the people they have served, they used to drop the money in that pocket.
In fact, the guineas used to be dropped.
Yeah, it's true.
I remember in Calcutta, this practice continued for a very, very long time.
Oh,
Of course,
okay.
perhaps we were not even lawyers or not even in the legal profession till then. You're absolutely right. There used to be a sort of a pocket where the money the change used to go, because even the change had a lot of value then. Today, change has no value.
Yeah. All right. So thank you for
And
that. Akansha,
It is
do you want
really
to say something?
commendable. Yeah, just a follow-up thing. It's really commendable when it comes from a senior advocate. That one thing, it's really satisfying when you see the kind of resolution that comes up in mediation. And secondly, that it also helps in changing that image which is created in the minds of people of how lawyers generally are. So that actually puts the image of those who are resolving the issue are not making it languish in the court. So thank you for bringing these 2 points out at the outside.
In fact, the lawyers who were trained as mediators, as persons, they have changed over the years.
I
Their
have changed.
personality has changed.
I have changed. I think
For the better.
Yeah.
For the better, yeah.
Exactly.
Yes, we're able to see more reasons. We're able
Yeah.
to sort of listen to the parties. We're able to hear the other side or what they want to say, instead of, you give the lawyers the mic and the lawyer will never leave the mic, like go on and on talking. But the ability to listen, the ability to hear the parties comes when you're actually a trained mediator.
True. Thank you for that, Mr. Batra. Dimitra, can you go ahead with the next question?
Yes, so thank you once again for sharing about your journey. Moving on to our next question. Since we have students also as our participants, could you tell us briefly what is the difference between arbitration and mediation?
That's a very interesting question, because both are ADRs. ADRs are alternate dispute resolution mechanisms. Even the arbitration is an alternative dispute resolution, and so is mediation, so is conciliation, so is lok adalat, so is judicial settlements, and so on. But there is a stark distinction between both mediation and arbitration. Arbitration is an adjudicatory process, while mediation in our country, that's what we practice, is facilitative in nature. The mediator, acting as a third neutral party, assists the parties in resolving their own disputes, writing their own judgments, coming up with options themselves. The mediator does not decide who is right, who is wrong. An arbitrator, it's a quasi-judicial process where the arbitrator, as a private judge, decides the disputes between the parties. So obviously, the arbitrator will decide A is right and B is wrong. And therefore, the award should be given in favor of A and against B. And that award is liable to challenge under the Arbitration and Conciliation Act. Although it is binding in law, it's like a judgment, it's a decree of the court under the new Arbitration and Conciliation Act of 1996. But mediation as a process is a settlement between the parties who sign the settlement agreement. The mediator signs the settlement agreement. In court-annexed mediation, the settlement goes to court. The court passes an order in terms of the settlement, which is like a consent decree or an order. And that consent or decree and order, the settlement merges into the court order. So the court order becomes a consent order or a consent decree. And therefore, the challenge to that by either of the parties is only on the ground of fraud. Because there is no other ground available. The party can't resign from the settlement that the party has arrived at. And therefore, the two are completely different. Even although both are structured processes, I would say that mediation is also a very structured process, but it is flexible. So is arbitration a structured process. Arbitration to a large extent is flexible, but the flexibility of mediation is far more in the process than in arbitration. And, arbitration, there is a claimant who files a claim statement, the other side comes and files a statement of defense, and the rejoinder is filed, the replication is filed, and then issues are framed. On the basis of the issues, the parties are set to trial. Okay, now you lead evidence. The other side leads evidence. The arbitrator will decide on the basis of the material before the arbitrator and take a decision. While in mediation, when we are talking to the parties in joint sessions, the mediator listens to the parties, understands their interests, their present interest, and their future interest. Then the mediator talks to the parties separately. Now, the arbitrator doesn't have any separate sessions. The mediator will have separate sessions with the parties because the entire process is confidential. And when it is confidential and we're having separate sessions with the parties say a lot of things which they don't want the other party to know. And therefore, the mediator creates that trust that I will not disclose this aspect to the other party. But in that process, the underlying interest of the party is culled out. So when we see the two parties with different perceptions to the problem, but their underlying interests in a lot of cases is very common. So when the common interests are put forward, the focus, the dispute becomes very narrow. And when that dispute becomes narrow, then you encourage the parties to resolve it so that their future interest is looked at. In arbitration or in litigation in courts, the court or the arbitrator decides a dispute of the past. For instance, a dispute has arisen in 2010, and the adjudication actually happens in 2014 or 2020. Now, the arbitrator or the court is deciding the dispute of the past. But in mediation, we stress upon the parties to look at their present interest and their future interest to decide what is best solution for them. So there's a completely different concept of arbitration and mediation. Arbitration is adversarial and mediation is completely not adversarial. Arbitration is evaluating, where the arbitrator evaluates the strengths and weaknesses of the parties and decides, while mediation is facilitative. So it's not evaluative. Although in some Western countries, they do sort of use the evaluative process also. But I think that's a little dangerous because then you tend to be, at least the parties perceive that the mediator is biased. The mediator is looking at it from a very biased point of view because he or she is giving their own opinion of the strengths and weaknesses of each other's case. So one has to be very careful in dealing with the parties. So I say when you're doing mediation or you're doing litigation or arbitration, your language, the words that you choose, the language of communication has to be very careful. The words have to be very carefully worded so that the parties don't take it amiss and they don't lose the trust and faith of neutrality that the mediator gives to the party once he begins the process. I mean, actually, I can even share I don't know how to share it on Zoom, but you can also share if you allow me, I can share a small PPT on the difference between arbitration and mediation, if you'd like. Will that be okay?
I think that would be fine, Mr. Batra. And if you think that if you want to share the same with our participants via email or something, because what I was saying that we are already completing 25 minutes. So if and if you want, but if you really want, then we can
No,
just
that's fine. That's fine. I mean, actually, this itself, I mean, this topic itself, we spend hours and hours to explain. So I think we can go on and on. I've got several, we've done several works on presenting PowerPoint presentations and so on in the training program. So that's all right. I can share it with you, and then you can share it with the parties if you like.
Thank you. Thank you. Akanksha?
So we had a hand raised, but I cannot see it right now. So if anyone wants to ask a question.
He was Rudra. Yes, Rudra.
Yes.
Rudra.
Please, Rudra, go ahead.
Good afternoon, everyone. Good afternoon, and good afternoon, sir. Sorry, good evening. I'm so sorry. Good evening. So, sir, I have a question for you. I want to know how much does the non-verbal communication impact on the arbitration and mediation with dealing with the parties? How much does it affect?
In arbitration, Rudra, there's hardly non-verbal communication. You're supposed to argue your case, and the lawyers are representing. Mediation, the mediation process is party-centric, and the arbitration process is lawyer-centric. So parties don't get so much of an opportunity to speak. It is the lawyers who are actually representing the parties before the arbitrator. It's not that parties can't do it, but that is what usually happens. And the non-verbal communication in mediation is very, very important. The mediator has to actually be alert to understand the body language of the parties, to understand through silence. Silence speaks a lot when the parties are talking. So non-verbal communication becomes more important in mediation when the mediator is talking to the parties together and separately. So the effect of non-verbal communication in arbitration is minimal. I mean, there's hardly any, because the arbitrator is going to decide on whatever material is there before the arbitrator. While in mediation, in order to understand the underlying interests, in order to focus them to think on the path of their future interest and their present interest, it is important that the mediator understands the non-verbal language of the parties as well.
I hope that
so much,
solves your. Thank you, Rudra.
Yeah, sure,
It was
sure.
a very good question, I must say, because non-verbal communication, like Mr. Batra mentioned, it is very relevant, because that is how mediation builds rapport and trust with the parties. And Mr. Batra, since you have already created that difference, described that difference between mediation and arbitration, I would also want you to deal with med-arb in particular and how relevant it is from practitioner's point of view and also the litigant's point of view.
Well, I think first litigants' point of view, because the main stakeholders are the litigants. The practitioners are there because of the litigants. The dispute is of the litigants, of the parties. So med-arb, I think, is a very, very interesting and a very, very effective tool or a forum to, not a tool, but a forum to opt for. Because once the parties make a genuine effort to resolve their disputes through the process of mediation, there is nothing better than that. There is nothing better than being able to resolve your own disputes rather than let a third party to decide for you what is right or wrong. As I said, the dispute is of the parties. The solution also belongs to the parties. So if you allow a third party to take a decision, obviously one is going to be happy, the other is going to be unhappy. And sometimes the person who wins also is unhappy because it's rather late in the day for him to win. So here the mediation process helps the parties, but for some reason, in case a settlement is not arrived at, instead of going to court, I think opting for arbitration as an alternative to mediation, if mediation is not appropriate, although I feel that mediation is not actually an alternate dispute resolution, it's appropriate dispute resolution. I don't like to call it an alternative. Alternative is arbitration. So if mediation has not been successful, and I don't call it failed because no mediation fails, if parties have actually attempted to resolve and they've not been able to resolve, then opting for arbitration is far better for them because it is less time consuming. But yes, there is a dark side to this also. It's expensive today. Arbitration is a very, very expensive process because the arbitration fee is very high. But the good side is that the dispute is decided in a very short span of time. The current Arbitration and Conciliation Act says it must be decided within 1 year or maximum 1.5 years. And if it goes beyond that, you have to go to court to seek permission to continue. You can give consent for maximum 6 months, but beyond 6 months, you have to go to court to take the consent whether you should continue or not. So the court can also see whether actually mediation the process of arbitration is being effectively undertaken or not. And if it's being delayed for some reason because the arbitrator is not giving enough time or the parties are delaying, the court will say, forget it. There's no need to give. Of course, by and large, the court does give consent, but because the parties have moved forward in arbitration. So ultimately, arbitration is much more speedier. And once that decision is given, you have a decree of the court which is ready. So if you go for a suit, the trial itself would take several years, while in arbitration, it would be over in 1 year or 1.5 years maximum. And so therefore, in that sense, it's much better. But there is another flip side to this, because the arbitration award is also challengeable under Section 34. But the good part is that the scope of Section 34 is very limited. It is in domestic arbitration is slightly different. In international arbitration, commercial arbitration is something different. But the scope is limited because only if it is against morality or it's against the public policy can that be challenged. So the court does not and should not, there are several judgments of the Supreme Court, go into the evidence of the matter. And the court doesn't sit and appeal over the arbitral award, but looks at it in a very narrow sphere. So, but even 34 takes a long time in the court. The practical aspect is this, because the courts are also burdened with so many matters. And we have a problem about, not so many judges as to the number of population that there is. So these kind of things will derail. Then after 34, there is an appeal against that, which goes to under Section 37. And after which it goes to SLP. So that process also is delayed. So it's better for the parties to resolve the disputes through mediation. If not, then go through arbitration. At least the arbitral award gets you a decree straight away instead of going through a first stage of prolonged trial in the courts. But there is another aspect to it. There is a med-arb-med. During the process of arbitration, if the parties, by then they know what their strengths and weaknesses are because they filed their claims and their counterclaims and the defenses, everything is there with the arbitrator. So inwardly, they would know what is the actual strength of the case. So again, they want to shift to the arbitration. The arbitrator can delegate them to mediation under Section 30 of the Arbitration Act. So Section 30 is also important. In that case, once they go back to mediation and a settlement happens, then that settlement goes back to the arbitrator who passes a consent award. Then it becomes a consent decree. So I would say med-arb-med is the best option. But of course, the arbitrator ought not to act as a mediator once he starts adjudicating. And I think I'll come to that later because that may be another big discussion.
I was about to ask, there were two follow-up questions in my mind. You already asked my first question, Mr. Batra, that can the same person be the mediator and arbitrator and then again the mediator? So I think that's,
Ideally, ideally, no. Ideally, no. The reason is that in mediation, there is a lot of confidential information which is shared with the mediator. And if the arbitrator gets that confidential information, there is a likelihood of the bias coming in the final decision. Because after all, every arbitrator, every judge is also a human being. So when the confidential information comes to that person starts tilting towards the party that he or she thinks is right. You know, so it becomes a very subjective. So the element of bias comes in. But there was a very interesting sort of case that one very senior mediator had attempted, and he sort of did mediation, and the parties insisted that he continues as the arbitrator. So he took up this job of arbitrating. But during the arbitration process, actually, sorry, it was not, he didn't start with mediation, he started with arbitration. And he told the parties that, why don't you attempt mediation? But the parties said, no, we want to continue with arbitration. So he says, all right, you go through the entire process. I will make my award. I will keep it in the sealed cover. Then you go for mediation. By then, you know exactly what your strength and weakness of the case is, and you will come to a decision. And he actually wrote an award, kept it under the sealed cover, and then he acted as mediator, because he'd already finished his job as an arbitrator. And once having finished his job as an arbitrator, he wrote the award, kept it in the sealed cover. And then during the process of mediation, the parties agreed to a settlement.
yeah.
And they signed it. Then what he did was, and he opened the award to show it to them that how the award would have been different from what they decided, and therefore tore that award, and the settlement became a consent award. So this is something which really, I think, was a very, very tactful way of helping the parties to write their own judgments, and they agreed to accept that their own decision. So one party would have been happy, the other not happy. So I think it's a process which the arbitrator should not ordinarily, ideally, should not act as a mediator.
Yeah. However, whatever that particular mediator slash arbitrator did, it requires a lot of expertise, and maybe it was by chance also that this entire decision was successful. But I also agree with you.
A very senior person, senior advocate from Chennai, who was also our trainer at the time when we were sort of undergoing training in 2000s.
All right, thank you. I think Rajiv has a question. Rajiv, do you have a question? Yeah.
I do for Mr. Batra. It sort of carries on from what you, Mr. Batra, you've been talking about, and it's the role of the mediator stroke arbitrator. And you have mentioned previously that you have been acting both as a lawyer, and for the past 16 years you have also been practicing as a mediator. And you said you change the cap, the hat which you wear. It depends on the type of case which you're dealing with. I presume that as human beings, we are not like machines that we can switch on and off. So how, I would personally find it quite challenging if I'm switching from one role to another. So any sort of tips you would, or your expertise, and how do you make that switch as smooth as possible?
That's a very, very interesting question. I think this comes with experience. It's important that we don't relate ourselves to the dispute, whether as litigator or as mediator. We are arguing in the court the whole day. 4 o'clock, we go back to the mediation center. and suddenly our hat changes. So we often, in the training program, tell the lawyers that you must first take some time to cool down and come into the mediator's role. So therefore, the questions that you need to ask are different from the questions that you would ask your clients or the other side's client in litigation. It's actually a difficult job, but I guess this comes through experience where you really need to switch roles. It's actually doing a different performance altogether. I don't know whether I agree with you that everybody can't do it. And that is the skill that we try and develop during the training program for the lawyers, that how do you switch? So I said the lingo, there is a legal lingo, there is a mediation lingo. So the words that you use in the court and the language that you use to sort of put your point across, of course, parliamentary language, not unparliamentary, but the kind of open-ended questions. So, how do you frame or reframe the information that you have getting from the party? So that I think Rajiv will come through experience. It's a difficult job, but it can be done. And this is one of our training programs on how to do it. And there's, we sort of do role plays and we go into open-ended questions. How do we ask open-ended questions? And if you ask close-ended questions, what is the impact of those questions? So you have to start thinking back. Your thought process has to change when you're sitting as a mediator.
Yeah. Thank you for that, Sudhanshu. And here, I also agree with Mr. Batra here that role plays and switching roles during the training really helps. So we are also, like AcIn's International is about to come with its second cohort from January 21, Mr. Batra, and we are starting with the second cohort of our mediation training. So I think Akansha will be sharing the link in the chat box. So there also we have planned at least 2 role plays per participant. It's a very small cohort that we create. And although people say that how real role plays can be, but it depends upon the person who creates the role plays and how marvelously that can be executed. So I agree with you. And hopefully, Rajiv, you got your answer there. Rajiv is joining us from London, I believe, right? What's the time there, Rajiv?
It's about 1:15.
1:15.
About.
All right. Thank you. So you're about to have your lunch there, I think. Yeah.
So I already I had an early lunch today, just
All
so
right.
that I don't miss it. Yeah.
All right. Thank you for joining. Thank you for joining,
Thank you.
Rajiv.
Yeah. Pleasure.
So, Mr. Batra, if you allow me, Rudra, I'll come to you, but then Parth has already put a question in the chat box. Parth, if you are there, would you like to unmute and ask your question yourself?
Yes, thank you so much. Greetings to everyone. Sir, I had a question to you. What if the parties are not satisfied with the mediation process? Now, what recourse do they have?
They can walk out. Simple. It's not binding on them. And we say that in our opening statement. Please feel free to walk out. Mediator has to be actually a completely selfless kind of a person, that he or she should not feel bad that the parties have decided to walk out. That means that, that first of all, that trust, that connection that the mediator needs to build with the parties, perhaps something is lacking there. Or, some of the parties are so rigid that they wouldn't want to open up. They wouldn't want to open up. See, this is a party-centric process. The parties volunteer here to come and resolve their disputes. We can't force them to do it. If the parties are unhappy, they're free to walk out. There's no problem. But it is a great thing that they were tempted to do it. And if today they were tempted to do it, they've gone back to the adjudicatory system. After some time, they want to come back. I have one case I had which went to court 4 times or 5 times because the parties were unable to settle. And every time they would come back. And ultimately, when it came, the parties resolved it. So that's perfectly fine if the parties choose not to continue with the mediation process. But the skill of the mediator is to show the path to the parties that this is the best possible solution available to them for getting true justice.
Yeah. Thank
Sir,
you.
so can they opt for another mediation session or directly engage in litigation? Is that an option?
Of course.
Or Mr. Batra, just one follow-up in this question of Parth only, or can they go in arbitration also? Which one would be better? I know you have already talked about med-arb arbitration as better as in comparison with litigation. So, and will the nature of the dispute make any difference?
See, parties can opt for arbitration at any stage. Usually, when there is a commercial deal or a commercial agreement between the parties, there is an inbuilt arbitration agreement. So the parties, once agreed at the initial stage, they have to go for arbitration. There's no choice. Now, during the pendency of a court proceedings, if the parties choose to go to arbitration, they can request the court can delegate them to arbitration. And during mediation, if the parties want to decide that, yes, we want to go into mediation, and both agree that they can go to arbitration, nothing stops them from going to arbitration. But if they choose to adopt the part of the court, they can do that as well. So choosing arbitration at any stage, whether at the initial stage or during the pendency of the dispute, there's no bar. You can choose arbitration anytime.
Yeah. All right, thank you. Parth, hopefully that answers your question.
Yes, ma'am. Thank you so much, sir.
So, Mr. Batra, the next question which I wanted to ask, I think Kriti in our meeting, she is already talking about that question in the chat box. So, Kriti, if you would want to unmute yourself and want to ask, or shall I go ahead and ask that if your network is a little weaker today?
Yeah, it is. I think if you can go ahead and put that question. I'm here listening now.
All right. Thank you. Thank you very much for that question, Kriti. So, Mr. Batra, Kriti says that arbitrability of matter is important in arbitration, but no such restriction is there in mediation. So, if a matter qualifies for mediation but doesn't for arbitration, what recourse can be taken up next? I think she's asking that in context of med-arb.
As I said, if there is an agreement between the parties in writing that they have to go in arbitration, they have no choice. They have to go for arbitration. Okay?
All right.
If it is not in writing, they can choose to either take the court path or for arbitration, in which case they'll have to have an agreement in writing that, yes, they agree to go to arbitration. They can have that separately, or with the consent of the parties, the court in a pending case can pass an order saying that the parties agree to go to arbitration, and then they delegate them to arbitration.
All right. And Mr. Batra, if there is a mediation going on, and there is one question which was sent to me directly by a participant. So if there is a mediation going on and the agreement is arrived at by the parties, and now they are signing it as a conciliation under the Arbitration Act 1996, and the mediator is going under the act under the 1996 Act. Is that med-arb, or is that model even possible?
See, that's a very interesting question. Now, I'll first clear the concept of conciliation and arbitration for you. We don't have a standalone law on mediation. We don't. In fact, mediation as a term was first used in 2002 when the Code of Civil Procedure was amended and Section 89 was introduced. Before that, no other act used the term mediation, but conciliation was there. Conciliation was there in the Industrial Disputes Act. Conciliation was there in the Hindu Marriage Act. Conciliation was there in so many acts. in the Arbitration and Conciliation Act of 1996, there is Chapter 3 that deals with conciliation. Since I said that there is no standalone law till now, of course, there is a bill which is happening, and perhaps there will be a standalone law on mediation as well. We've had a lot of discussions on that over several forums. We've worked on those mediation bills. We've given it to the Parliamentary Standing Committee. I was also invited to give my presentation on that. But as of now, what is conciliation? Conciliation is actually pre-litigation mediation. Now, what is pre-litigation mediation? Before the parties choose to go to litigation, before the parties choose to go to arbitration, before the parties choose to go to the court, they decide that they will go to a third neutral party of their choice who will conciliate between them and find an amicable solution. Now, once that conciliation process happens, that is provided under Chapter 3 of the Arbitration and Conciliation Act from Section 61 to 74, 75, if I correctly recall, 61 to 74, 75. That process is very, very similar. That process, sorry?
It is 73. 73, 74.
74,
Yeah.
74. So actually that process is very, very similar to the mediation process. But once a settlement is arrived at, it can't go to court because the parties didn't go to court. Correct? A settlement has happened. Now, how do you enforce it? You see, in mediation, court-annexed mediation, the court sends the parties for mediation. The parties settle. The settlement goes to a signed settlement between the parties and the mediator goes to court. The court passes an order. The settlement merges in the court order. That becomes final. Now, in conciliation, where the parties have not gone to court and a settlement happens, how is it enforceable? Section 74 of the Arbitration and Conciliation Act says that that will have the same effect as an arbitral award. So that settlement is enforceable like an arbitral award under Section 36 of the Arbitration and Conciliation Act. So there is enforceability even of a settlement arrived at between the parties before they've gone to court through a neutral third party. And that settlement document has the effect and status of an arbitral award. That's the language used. Effect and status of an arbitral award. So therefore, even that is enforceable in law. What we are talking about, mediation and conciliation, is not something which is outside the judicial process. Both are now part of the judicial process because Chapter 3 of the Arbitration and Conciliation Act makes it mandatory that that settlement arrived at through the process of conciliation becomes an award and therefore a decree of the court.
Yeah.
I hope that answered this.
To me, it is, and I think it is quite clear to our participants also. And that is something I think we have such a beautiful instrument ready to be used in already present there in our law. And I think it is underused. Maybe because in curriculums, in colleges, teachers themselves, professors themselves are unaware of this option available. Because let me tell you very frankly, Mr. Batra, there are a few friends of mine who were in their matter. They came across this. It was a family matter and it was a pre-litigation issue. And we were having a discussion on this. And then it came up. And yes, it is usable. It can be used. Then another follow-up question is, Mr. Batra, that you might find it a little novice, but I have to ask because there are even young mediators in our gathering today.
Don't shy away.
Thank you. So once we have that conciliation ready with us, signed by the parties, number one, I think the mediator is not supposed to sign it, or is he or she supposed to sign it?
Conciliation.
Yeah, conciliation, mediation,
mediation. Both conciliator and mediator has to sign it. Yes.
All right, and all right, and even if it is it is a pre-litigation, correct. And second thing, Mr. Batra, does it go through a process of registration or not?
Very interesting question again. See, a decree, let's say there is a partition suit. Okay. And a partition suit partitions immovable property. It gives the shares to some party, shares to some other party. I mean, shares are sort of demarcated and the mode of partition. Now, how do you execute that decree? You cannot execute the decree because it involves immovable property. The decree itself needs registration. So where a document is compulsorily registrable under the Registration Act, it requires registration. So if a settlement, which is either a deemed award or a decree of the court, by the court passing through mediation process, is providing title of an immovable property to one of the parties, that award will become registrable, not all. If it is between matrimonial dispute, it doesn't require registration. But if it is about dividing the properties,
then it will go under 17.
Then you have to invoke the registration. You have to see what document is compulsorily registrable. Then that settlement becomes registrable. Otherwise, not.
Thank you for clarifying that, Mr. Batra. And it's really helpful to me also. Thank you very much. I think we have one more question from Vani. All right, Vani, can I come to this question a little later, because there is a flow that we are going in some direction with regards to MedArb. Rudra, is your question with regards to MedArb or something else? So if it is with regards to MedArb, then please go ahead and unmute yourself and ask. All right, I think, Mr. Batra, we can go to the next question. Dimitra, can you ask your next question?
Yes, Mr. Batra, how often do you see MedArb clauses in commercial matters? Because at times, some agreements have negotiation between parties as one of the clauses of dispute resolution. Does absence of the term mediation in the clause also enable opting to MedArb?
In commercial matters, mediation has been very, very effective. It has been, in fact, day before yesterday, we had a panel discussion with the Delhi High Court. I was moderating that panel discussion between the Supreme Court Judge, Justice Kaul, Justice Sikri, former Supreme Court Judge, the Attorney General, and Justice Manmohan, present sitting judge of the Delhi High Court. I and Sadhana Ramachandran, both of us were moderating the panel discussion. And one of the judges pointed out, from our statistics of Samadhan, that 85% of the IPR matters referred are resolved through mediation. So you can imagine what kind of commercial matters are being resolved through mediation. When mediation started, we thought, it's best for matrimonial disputes or family disputes, but it's gone much beyond that. Today, I have mediated or I have facilitated parties in resolving patent disputes at the pre-litigation stage. Trademark disputes during litigation. Commercial disputes of construction through mediation. Joint venture agreements through mediation. Company disputes under the Companies Act or the IBC through mediation. So mediation has been very, very effective in commercial disputes. And I can tell you, I am now very comfortable doing mediation online, especially for commercial disputes, where there is a relationship between the parties, which is a commercial relationship. Emotions are less, but in personal disputes, emotions run very high. It is better to have a physical mediation and conciliation rather than through the online process. So in commercial disputes, I think mediation has really gone very far. And now the Singapore Convention also has talked about international commercial disputes having the effect or having enforceability. So, I mean, I think for commercial disputes, this is going to be one of the most sought after processes that people will ultimately resort to.
All right. Thank you, Mr.
Rajiv,
Bhatt.
Rajiv had his hand up or he had his thumbs up. I saw something.
He gave you a thumbs up. Yeah.
Yes.
Thank you,
Yes.
Mr. Batra. So I think if you allow us 5 to 7 minutes more, we will open the floor. There are quite a few questions coming to us in the chat box. We had few more questions planned to ask from you, but I think we should give the floor to the participants here, and
Sure.
maybe that is more helpful to them. So I'll invite the questions put in. Vani, would you like to ask your question? Unmute yourself or ask your question. Go ahead.
Oh, good morning, good evening, ma'am. Good evening, sir. So my question was, what advice would you give to someone who wants to just set off in a similar direction as you are?
I'm sorry, I didn't get your question.
Her question is, what advice would you give someone who wants to set off in a similar direction? So I think she's trying to bring in the concept of set off in this.
Set off in the sense, what would be my advice for people who want to opt for this process
Yes, sir. Yes, sir. Sure. Yes, sir.
I think, Vani, I think everybody should undergo training in mediation. Today, I must confess, as a mediator, it's not very lucrative. You can't survive only on mediation because it's not so well paid in India. Abroad, in some of the states in the US, in Toronto, in some of the other countries, it is extremely well paid. In the US, not in all states, in some states. And I think eventually it's going to be a very, very lucrative business, but it's going to take a long time. So therefore, my advice would be definitely be a litigator if you want to be in court practice. Litigation is another ball game. It's another charm. It's great to argue a matter. It's great to go through that because there are certain statutes that are so beautifully drafted, and some of them have become archaic and so on and so forth. And you're dealing with both commercial aspects, human aspects. So the human aspect, the law unfortunately is not able to deal with it so well. But definitely you must undergo training in mediation, and you must also continue to practice, because mediation proficiency can only come in if you practice mediation. Just by attending workshops, attending seminars, getting trained is not enough. Mediation practice really comes when you have an exposure to how to deal with parties, how to help them resolve the disputes in the practical experience. So I think mediation in the near future, I mean, it might take some time. I don't know, in near future or in the future, I must say, will definitely be a very, very sought after profession.
Thank you, Mr. Batra, for that answer. I totally agree with you that mediation should be, people should go beyond from looking mediation just as a profession, but take it as a life skill. And I think one of our delegates was here in the meeting, Advocate Arup Datta. He joined our first cohort of our training in September, October 2022. So it was such an overwhelming feeling towards the end that 15 in total, we had 15 participants, and everybody towards the end of those 6 days, everybody realized that yes, it is just not only adding a feather in your cap, but actually evolving yourself as a human being.
You very rightly said it's a lifetime skill that you learn, and it helps you at home. I can tell you can change as a person at home. You're dealing with. So I think everybody should undergo. There used to be a time when I joined the profession, I said, I used to say everybody should do a course in law, because law is so important. It opens up your eyes, your ears, your mind, everything. But today, I say that along with law, you must undergo training in mediation. It is so very important to change your own
In the
lifestyle.
same direction, we also call our trainings the mindset trainings, because like Upasana said, the conflict resolution, it is not just going to help you in profession. It is also going to help you in all the relationships that you build, whether it is
Very
your
true.
workplace, whether it is your family, whether it is community, society in general. So everywhere with human interaction, conflicts are going to arise. So how are you going to interact with the non-violent communication? How is that going to take place? So it is the mindset training that happens in mediation training, how people are going to communicate. So
I
very
see
well
I'm
said there.
becoming a good mediator in the future.
No, actually, Mr. Batra, because there are these discussions really help the entire. It helps Records International, me, Akansha, and everybody in the list of participants, because since mediation is such a confidential process. For example, there is one participant of ours who has written, could you share a few videos to us to have knowledge about how mediation is taking place, like moot court. So, for example, these videos, people are quite aware about what happens in a courtroom in an adversarial process. But mediation is such a closed door process that even it's not quite widely available, and mediation competitions are actually making it look something else. It is not what in a competition happens. So
The partner, the maximum litigation or litigator is the government in courts. So the people in the government actually should change their mindset and opt for mediation. PSUs, banks, other financial institutions, or government departments. I think it's important for them to take this call. And once they take the call, it will percolate down to the people much faster than how, of course, you're absolutely right. We need to get into these discussions, make people aware. And awareness of this process is very, very limited. And the more we organize these seminars, the more we organize these discussions, people will be aware and then perhaps opt for this themselves rather than somebody telling them to do it.
So, Mr. Batra, we just received a registration from an ASP, Assistant Superintendent of Police, and we are so happy about it that even police personnel is getting interested in this process. So I think I totally agree with you.
Next week, the Haryana Public Service Commission invited me to give a talk, but unfortunately, I'm not available at that time. But yes, that means I was very, very glad to know that the Haryana Public Services Commission is also organizing these events now.
Yeah.
So it's a good thing, this is how the government agencies, the state, the instrumentality of the state should start changing their mindset and opt for this kind of a process, which is much more useful.
Mr. Batra, I would like to invite Rudra to ask his question. Rudra, can you please, and this would be the last question for today. We have booked 1 hour of yours, Mr. Batra, just so we apologize for taking 10 minutes more.
No problem.
Rudra,
Thank you, ma'am, for yes, ma'am. Thank you for taking my last question. Sir, I have a question that the topic of today's meeting is Mediation and Arbitration Act, MEDAR. But we are talking about the act in this topic is Arbitration and Conciliation Act. So I want to know what is the difference between mediation and arbitration. Sorry, mediation and conciliation. And how does the mediation differ from
Mr. Batra,
conciliation?
you were right. I think, Mr. Batra, you were right when you wanted to show your PPT, and that was my bad, I think.
No, that's bad. No. The concept, Rudra, of the difference between the mediation and conciliation, I've already explained, and I think that's quite clear that why we resort to the Arbitration and Conciliation Act is because the conciliation enforceability comes through that act. There is no standalone law on mediation. Mediation is found in Section 89. courts refer the parties. The parties go back after the settlement to the court that referred the parties, then passes an order. But for conciliation, we need to resort to the Arbitration and Conciliation Act because there is a full chapter on this, which makes the conciliated settlement enforceable in law. The enforceability of a settlement is extremely important. Now, just imagine a case where parties have, sat together and they decided to settle the dispute and they signed some agreement, not through the conciliation process. Can they call that an award? Can they call that a conciliated settlement? No, they can't. That's a compromise. So if there is a breach of that compromise, they have to go by way of a suit. They can't say, please enforce it. So if you adopt the process of conciliation through the process given in Chapter 3, that's why we resort to the Arbitration and Conciliation Act. While mediation comes through Section 89. I hope that's clear.
Yes, sir. Thank you so much.
And Rudra, the topic of today's discussion was Med-Arb. So I think you got a little confused there. We are not discussing the bill here, the Mediation Act that is about to come. The bill is pending in the Parliament. You can watch our fireside chat on the mediation bill on our YouTube channel. It goes with the name AcIn's International. Prateek will be sharing the link in the chat, and it is a very interesting discussion on the mediation bill if you're interested.
Okay, ma'am. Sure.
Thank you. So I would like to thank you, Mr. Batra, for joining us today. It was such a lovely conversation. I cannot communicate that to you through a virtual meeting. So I would request an in-person meeting with you now. I'll ask Kriti to organize that. I would really love to meet you in the High Court whenever, because I also generally visit the High Court. I come and meet you whenever you're there.
Sure.
I think it'll be... please share your final comments.
I think you people are doing a great job. The curriculum of mediation and conciliation should be uniform in all law colleges. I think you should focus on setting out a proper curriculum because there is a lot of inconsistency. You did rightly say that there is a lot of confusion about conciliation, mediation. People are not aware of Chapter 3 and so on. There are so many other areas. So I think what is important today for law students is to, especially the faculties, to sit down together and work out a curriculum which is consistent for all law colleges. Because the other subjects like the Contract Act and the Family Law, you already have case laws and you have statutes. Here there is no statute, it's not codified. So in order to have consistency in the entire process, it's important that the curriculum should be in the right place. And I think I would urge the faculty members to work more on that so that that clarity is there and people don't sort of have their own ideas of mediation and conciliation, because the whole process will otherwise get derailed. Thank you so much. It was a pleasure meeting all of you. We hope to see.
Thank you. Thank you for joining.
Thank you for joining, Mr. Batra.
Thank you so much. We had a lovely conversation. I hope our participants had a great learning opportunity.
Yes.
Thank you. So we are sharing few links in the chat box. Please follow us on LinkedIn. We are sharing the link for our upcoming mediation training in the chat box. If you are interested, there are scholarships available for academicians, young professionals, students, special student opportunity to observe role plays during the training. So we are sharing the links in the chat box if you want. Our website link is also there in the chat box. You can follow us on LinkedIn and get all the update from there also. We are sharing a link to our WhatsApp group, Conflict Resolution India, in which we have participants from all around the world, restorative justice facilitators, mediators, arbitrators, and it's more about conflict resolution rather than only mediation. So if you feel like you can have, you can join us there also in that WhatsApp group. So thank you very much.
Thank you. And do send me these links on WhatsApp, please. I may not be able to copy it from the chat box.
Definitely.
I'll send you all the links. I'll send you all the links, Mr. Batra.
Thank you.
I'll just do that.
So
Bye-bye.
if you hear 10 pings in a row, please, we apologize in advance for spamming you, but then we are gonna send that.
Fine. As long as you do it as a one-time thing, that's all right.
Perfect. Akansha, please note that.
Noted.
Thank you.
Thank you.
Have a
Bye-bye.
great evening ahead. Bye-bye.
Bye-bye. So, Sonali, we will ask Mr. Batra to send us his PPT and we will share it with you. Maybe you can, we can share it with all our registered participants, Akanksha, on email, if that is possible. You can follow us on LinkedIn, Sonali. There is also, you can find that PPT from LinkedIn also. We can put a link on a post, right, Akanksha?
Yeah. So we'll put a copy of this.
Akanksha, can we share the
Conver-
links in the chat box now?
We have shared all the links in the chat box. I'm
I
also
think-
sending the link to the WhatsApp group for all the legal updates.
Prateek, can you share the link of the WhatsApp group here?
I'm on, oh yeah, I'm sending that. You can
So
use
this
this
is
group
the-
for information about our events.
All right, this is the group for legal updates, right, Akanksha?
Yeah.
You can join this.
Yeah, and follow us on LinkedIn so that you are getting regular updates as well there. Right, so I think we can, if you have copied all the links, we can switch off, we can log out.
Can you share the link to the student opportunity also, Akanksha, again?
Ma'am, also, can you share the YouTube channel link which you were
Yeah.
talking about?
All right. So perfect.
We can stop the recording. That's possible.
Can you stop the